Here and ready to go. And welcome everyone to the keynote session for today. My name is Fred Roberts. I'll be introducing our keynote speaker, and I'll remind everyone that the session is being recorded. So I'm very pleased to invite Solon Baracas to the stage today. He's a principal researcher in the New York City lab of Microsoft Research. He's also an adjunct professor in the Department of Information Science at Cornell. His research explores ethical and policy issues in AI, particularly fairness and machine learning, methods for bringing accountability to automated decision-making, and privacy implications of inference. His talk today is titled Unavoidable Tensions in Explaining Algorithmic Decisions. So I'll ask that everyone hold their questions until the talk is finished. And welcome, Solon, and thank you for joining us today, and you're on.
Thanks so much, Fred, and thank you to all the organizers for the invitation to be here. Maybe a special thanks to you, Fred, too, for pronouncing my name correctly, which is pretty difficult on a one-shot basis, so well done. Yes, so I'm very pleased to be here with you all. I'll be presenting some work, which is sort of pulls a little bit on some work I've been doing over the past few years with my colleagues, Andrew Supps, who's a law professor at UCLA, and Manish Raghavan, who actually is now at Harvard, I realize, but was a computer science student at Cornell until quite recently. I'll just jump right into it. So I think sort of the best place to start with a talk like this is to maybe go all the way back to what feels like the original motivation for a lot of discussion around interpretability and explainability in machine learning. And for years, there's been this kind of perceived tension between interpretability of the models that we can produce and the performance of those models. And this idea that there's just sort of a trade-off, you have to choose one or the other, is a very well-accepted and well-entrenched idea in the community. And when I explored this many years ago, what I discovered is that though this is sort of based on practical know-how and a lot of kind of real-world practice, there's not really a lot of empirical work that demonstrates this, and there's certainly no formal proofs that show that this tension always needs to apply. And nevertheless, this has sort of been like the motivating tension that has gotten a lot of people to work on this issue, specifically in the technical community over the past decade or two. And so this is not to say the trade-off is not real. It's just that we still, even to this day, don't really have a good understanding of when that tension will apply and under what circumstances we'll have to make these kind of trade-offs. But nevertheless, there's kind of ongoing debate around this. And certainly some very serious scholars think that this trade-off can be avoided in most cases. And in fact, when we're making high-stakes decisions, for example, in the criminal justice system, as Cynthia Rudin has argued, we have an obligation in some sense to choose those models that are more interpretable and can do so often without having to sacrifice performance. Nevertheless, I would say that over the past 5 years in particular, we've kind of observed a clear move away from building interpretable models in the sense that you can look at them and sort of understand what they're doing, understand their internals. There's been a move away from that kind of work to just trying to explain the decisions of the model. So forgoing any attempt to understand their internals, but instead trying to give an account for how the model arrived at a particular decision. And that's what I think is often kind of understood as like the explainability move. So a move from interpretability to explainability. And interestingly, this seems to also have been at the heart of what was originally kind of this really quite fierce debate about whether or not what was then going to be the kind of new GDPR requirement for a so-called right to explanation sort of conflicting with machine learning. So some really early work on this topic kind of gave the impression that maybe machine learning is somehow incompatible with what was going to be the forthcoming GDPR requirements. That if you couldn't build interpretable models, that you couldn't actually deploy them. And I think the emerging view on this is that the law doesn't actually create a blanket prohibition on non-interpretable models, but it does require some degree of disclosure such that data subjects can vindicate their rights under the law. And what that probably means in practice is often things like providing explanations rather than necessarily building these inherently interpretable models. So this is kind of like setting the stage a little bit, but this remains, I think, an interesting concern because you can kind of cast it in slightly different ways as well. So the second tension that I think is worth considering is that maybe simplicity, meaning maybe like simpler models that we can more easily understand, possibly come at the cost of fairness. So not just performance, but fairness in particular. And so there's a kind of interesting irony here, right? So certainly in lending, there's a long-standing concern that the reason that some people are not well assessed when they apply for a loan is that the models are insufficiently complex to kind of capture some of the relationships that would explain who is likely to default. And so the thinking there is that if we get new data and if we have new, often much more sophisticated learning methods, we can develop models that are going to perform better specifically for these populations. And yet it turns out that maybe that degree of complexity is what makes these models uninterpretable, more challenging to understand. And so there's a sense in which we have kind of conflicting desires. We want to understand what the model is doing to make sure that it's not acting unfairly. But we also want the model to be complex so that it could actually do a better job in assessing applicants for credit that historically were not well assessed. And in some work that John Kleinberg and Sendel Mulathanen have done, they've even actually done some theoretical work to show that this can be a hard tension in some case, where the desire for simplicity will directly conflict with some of the kind of fairness metrics that we've developed over the past decade. The third tension I want to kind of reflect on is that despite the fact that there's been a tremendous amount of work on this topic recently, there really is no universal definition of what counts as interpretable, and there certainly is no universal understanding of what constitutes a good explanation. So interpretability, and I think in much of the literature, is often operationalized as some kind of measure of complexity, right? So are we actually talking about a linear regression, or are we talking about a deep model? Right? But this is not really like what we mean in practice when we have to hand a model to someone. What counts as interpretable is deeply contextual. And it often depends on for whom this kind of model is being made available and for what purpose. And so some colleagues at Microsoft Research, Jen Wortman-Bon and Hannah Wallach, have a nice piece from a few years ago, kind of trying to lay out these questions. And I should say that I'll make these slides available, or you can click on these links. But the main purpose here of this work is to kind of show that what counts as interpretable will just be highly dependent on who is actually going to be looking at it and what they actually want to achieve. And there really isn't a way of just like defining what this counts as without actually taking these things into account. And one of the things I'll really stress over the course of the talk is that a lot of the debate about the quality of explanation. So here we're not talking about if the model is interpretable, but instead, what counts as a good explanation. A lot of the discussion has been about the fidelity of the explanation, meaning it's like, is the explanation accurately describing what's happening in the model? And what is sort of lost in the focus on fidelity is this understanding that actually there are many possible ways to explain the decisions of a model that are all equally accurate, but they actually all are very different from each other. Right? And I'll get into some details about this. There's many possible ways to explain things, all of which are accurate, but they might differ from each other in pretty dramatic ways. And which of those actually is more preferable or more desirable will again often depend on context. So to kind of situate this a bit more, at least in the kind of US legal context, I'll point out that though this discussion about a right to explanation in the GDPR was kind of perceived at the time as very novel, as a kind of legal innovation, there's long-standing laws in the United States that require something quite similar, specifically with respect to credit and lending decisions. So here in the US, we have the Fair Credit Reporting Act and the Equal Credit Opportunity Act. The Fair Credit Reporting Act is largely a privacy and transparency law. It requires that people have access to the information that's being used to make credit decisions. Equal Credit Opportunity Act is a discrimination law. And Regulation B here, I should say, is sort of like the rules interpreting the Equal Credit Opportunity Act. So kind of filling in the details a bit. All of these have what are known as adverse action notice requirements. And what this actually means in practice is that when a lender rejects an applicant, or in fact, when a lender actually offers a loan on less desirable terms than the applicant has requested, the lender actually needs to give an explanation for that adverse outcome. And that explanation actually needs to include some specific information. So the statute says that no factor that was a principal reason for adverse action may be excluded from disclosure. And then creditor must disclose the actual reasons for denial. And what's very notable, and this actually requirement is decades old, it actually even says that no more than 4 specific reasons are really necessary. The idea of thinking that if you give too many reasons, it will easily overwhelm the consumer. So already in the law, and for many decades, there's been this requirement for what are essentially sparse explanations of models' decisions, only highlighting some small set of features that really matter to the outcome. And since 2007, so 2017, so for over 5 years now, the Consumer Financial Protection Bureau, which is another agency here in the United States that has legal authority for enforcing some of these laws. It's the agency that was brought into existence here following the financial crisis, in 2007, 8, 9. And it's sort of a combined consumer protection agency with a focus specifically on consumer financial products. And they've been very worried about the compatibility of these requirements with machine learning. Many years ago, they were requesting information from the community, both from industry and from experts in the academy and civil society. And they were kind of concerned that, are there challenges in determining and disclosing to applicants the principal reasons for taking adverse actions or describing the reasons for taking adverse actions in a manner that relates to and accurately describes the factors actually considered or scored, specifically when using some of these new modeling techniques like machine learning. And there was actually even a second round of requests for information. This was actually issued at the tail end of the Obama administration. Even during the Trump administration, there was further requests for information. And just a couple of weeks ago, like I think 2 weeks ago, the Bureau issued a circular. So a circular is essentially a kind of formal announcement to the community to help clarify the meaning of the regulation. And what they actually clarified was something remarkably straightforward, which was, from my perspective, a bit disappointing. What they basically said is that these laws that have this adverse action notice do not permit creditors to use complex algorithms. When doing so means they cannot provide the specific and accurate reasons for adverse actions. So you might read this and you might think, oh, this is an extremely hard constraint. This is exactly the constraint that people were worried about when we were first talking, for example, about the GDPR. And in particular, what they say later in the circular is that a creditor's lack of understanding of its own methods is not a cognizable defense against liability for violating this requirement, right? So even if they don't understand the model, they can't say that that's why they haven't explained the outcome to a specific consumer. But actually, if you dig into this, this is not a particularly strong constraint. This is not a requirement that the models be interpretable, because the adverse action notice requirements, as I'll say much more about in a minute, only require that you explain the decision. They don't require that the model itself be interpretable. And those are different things, as I've been talking about. So in our reading, and here I'm drawing on some work that we've done a couple years ago and some more recent work by others, these requirements don't actually prohibit, don't create a blanket prohibition. Instead, what they really kind of encourage people to do is figure out how to use explainability techniques effectively. But the question here, and this is where I think the tension comes in, is whether the explanations we actually give of these outcomes actually serve the purpose that the regulators think they do. And so historically, and in fact, the circular even talks about it, the adverse action notices were thought to serve a couple different functions. So one was to kind of reveal when a decision might have been based on erroneous information. So for example, if your credit report had some piece of information that was decisive to your decision, but that piece of information was outdated or just simply wrong. It was also thought to maybe be a way to root out discrimination, because people who had to explain their decisions might be less likely to discriminate. More in keeping with some of the recent work in computer science, it was thought to be a way to educate consumers so that they would know how to maybe adapt their behavior so that when they apply for credit again in the future, they'd be more successful. And the circular even points out that Congress thought that this could be a way to foster competition, that somehow if lenders had to explain these things, that maybe in the marketplace, consumers would favor those that do a better job. All this seems quite sensible, but what I'll try to point out now is that these explanations, at least as the law requires them, don't really seem well positioned to serve those functions. So to begin with, the law doesn't require that the explanation explain why or how a disclosed factor affected the decision. So if you think about that explanation I received from Verizon, it just sort of says this feature, right? It doesn't say you used too much of your, you spent too much time on the phone or too little amount of time on the phone, or, there wasn't some sense of like directionality or the magnitude of the problem, right? But even more remarkably, there doesn't even have to really be an intuitive relationship between the factor that's held out and your creditworthiness. So in my case, right, how should I even conceive of the relationship between the way I used my phone and the likelihood that I'm going to be perceived as creditworthy. Like I have no intuition for which patterns of phone usage actually relate to the perception of creditworthiness, okay? And the law doesn't require any of that. In fact, what's even more remarkable is that under the previous administration, the CFPB even presented this as a desirable property of the law. They say that this flexibility may be useful to creditors when issuing adverse action notices where the variables and key reasons are known, but which may rely upon non-intuitive relationships, right? So they can have models that have completely non-intuitive relationships. No one will understand why that predicts the outcome. That doesn't matter. All that matters is that you be able to hold out the factors that actually are decisive to the decision, okay? So this gives you, I think, a sense that like, even if we want to actually obey the law, there's a lot of latitude here to think about how to go about things. And this is exactly what some of the work that the three of us have been doing in the past few years, because there's no one correct way to explain these decisions, right? As I'll kind of say a bit more in a moment, we can have many possible ways of explaining decisions, all of which are accurate, but some of which might be more helpful or at least better able to serve the functions that Congress and regulators think. And nevertheless, as I keep on harping on about, what's been pretty disappointing about the Bureau's actions in this area is that the focus continues to be about sort of accuracy and fidelity, right? They want to make sure that the explanations that people receive are accurate explanations of what's happened without, again, thinking about the fact that there's many things that could be accurate, but they could differ quite dramatically. So let me actually emphasize this concretely. Regulation B, as I mentioned, is this kind of, it's trying to explain how you can comply with ECOA, the Equal Credit Opportunity Act. And in that document, they actually describe some methods that creditors could use to generate these adverse action notices. And they're quite weird, actually. So they offer two possibilities. The first is to identify the factors for which the applicant's score fell furthest below the average score for each of those factors achieved by applicants whose total score was at or slightly above the minimum passing score. It's a mouthful, but what that's basically saying is like, take the population of people that you've given credit to in the past, the people who've been successful when they've applied in the past. Take that entire population, average the value of their features for each feature, and then take the applicant that you've rejected and then report the features from which that applicant that was rejected is furthest from the average of the population that you've actually given credit to in the first place, right? So what this is essentially suggesting that you do is find like the dimension along which someone is sort of most deficient, if that makes sense, right? They're furthest away from what was the average value of the population that you gave credit to. The second idea that they float is even more strange. It says not even the population that you gave credit to, but just the entire population. So everyone who's applied for credit ever, okay? Compare them to the average value of each feature for the entire population. Now compare this to what has been the, I think, dominant way of thinking about explanations in the computer science literature, which is what has been called counterfactual explanations. And here, the idea behind counterfactual explanations is very straightforward, very elegant. It's sort of saying, in trying to determine which features to highlight as those that are decisive to the decision, what we should do is find those that, if minimally changed, the smallest change we make, would alter the output of the model, right? So you can think of this as being, find those things that we should hold out as features that are important, because in theory, consumers could do the least amount of work to then change the outcome, okay? So these are radically different views about how to generate these sort of adverse action notices, about how to highlight which features are important, but both of them would be correct, right? Neither one is somehow, more correct than the other. They're simply different ways of trying to decide what counts as most important or decisive or sort of useful. And you can even think, if you want, that there are sort of normative reasons to favor one over the other, right? So you might think of this suggestion about finding the dimensions along which someone is most efficient as sort of a focus on procedural justice. You sort of want to understand the dimensions against which you were like held most accountable, right? Like, this is the real mark against you. This is where you fell down the most. Whereas you might think of counterfactual explanations as focusing on agency. We want to like actually give people information they can act on and do something with. And so what's most important is actually to highlight those things that they can act on. And again, both of these I think are reasonable normative justifications for favoring one over the other. But there isn't a correct answer here. There isn't one reason to favor the one over the other. It will sort of depend again on what you're trying to achieve. And before I kind of finish up this section, what I'll just say is that as far as we understand, the legal requirements allow lenders to choose. They could actually do any of these things. The question is, which of these actually serve the intended regulatory goals of legislators and the regulatory agencies, right? And that is not what is addressed by the Bureau's recent circular. Okay, I probably should speed up a bit here. The next section I want to talk about is that there really are no ways to avoid making subjective choices when explaining a model's output. Part of that is, I think, captured by what I was just discussing. But I think there's a way to get a little bit more technical here too. So I might have to race through this a bit, but before we can even figure out how to identify those things that might be, for example, easiest for a consumer to change, and here I'm thinking about counterfactual explanations, we need to actually answer some difficult questions, and I'll just actually get right to them rather than reading the questions to you. Okay, so the first one is, can we reasonably assume that when we say that someone should change a particular feature, that feature change that is being suggested nicely lines up with a real action that they can take in the world, right? So for example, if I say, you have to increase your income in order to be successful when applying for a loan in the future. Is there some discrete action in the world that I can take that increases income? In this case, I think we understand many of the possible things as people that we can do to increase income. But as I'll show here, those things aren't sort of, independent, nicely isolated, discrete actions. Often, there are other actions that have the effect eventually of a change in income. So, for example, we can probably do at least two things. We can try to get a raise, which is what I'm showing here with this kind of 0.1, where it actually would increase. If you can see my cursor, which I think you can. If we start here, you can see that we're on the wrong side of the boundary. But if we get a raise, well, actually our income will go up, okay? But note that actually we still haven't gotten across the boundary, because it might turn out that the length of employment is also important to the decision, but that's not being held out as one of the things that we need to actually account for. Or alternatively, we might wait for a raise. We might stay at a job. Yes, getting the raise by, right, I got this reversed. The alternative would be, one is getting a new job that's higher paying, the other is waiting for a raise. But again, if you wait for a raise, you can find out that, you get to the other side of the boundary, but this is not what would have actually been suggested, right? Because you've been told to increase income. So what this is really trying to point out is that often, increased income doesn't correspond to some discrete action in the world, or it corresponds to other things, and those actually might affect many features simultaneously, some of which might be important to the model, but which are not being held out as important in the explanation. The second thing I'll say is that features are not naturally commensurate, right? So what does it mean to sort of say that it's easier to increase income rather than increase the length of employment? How do we actually even compare those things? These are not similar units. You might think that the natural way of doing this is to kind of think in terms of real world costs, but we don't really have access to that information. We don't really know how costly it would be for people to do this. And so in practice, nearly all of the work that's been done over the past 5 years on this topic has just relied on normalization techniques, which basically look at the distribution of feature values in the training data. And they then try to find some way to kind of put things on a similar set of units. But very subtle differences in the way that we scale features can just flip the things that are seen as being the relevant feature to highlight. So here I'm just showing that if you scale the features differently, it will just flip the thing that you are going to highlight as being the feature that's worth changing. So again, there's a kind of assumption that we have to make about what is a reasonable basis upon which to decide how to compare incommensurate features. And as I was saying, these costs and circumstances that we might want to use as the basis for kind of reaching, putting these on equal footing is really not available to people. And finally, the costs and circumstances that individual people face might differ. So even if you could do this on average, right? Because on average, it's more costly to change your job than maybe to get a raise. It might just differ dramatically between people. And so there's not going to be some way of knowing that for a particular person, this is in fact the easiest thing, whereas for this other person, this is the easiest thing, okay? I will maybe skip this in the interest of time and come back to this if you have questions. It's about gaming, which I have a lot of thoughts on. Okay, but let me finish up maybe with the final couple slides. So yeah, to kind of round out this point, there's lots of research underway that is trying to develop a more principled approach to generating these counterfactual explanations. A lot of it is just extremely thoughtful, but ultimately, it's all different kinds of heuristics about how to solve these problems, different assumptions we might want to make in order to ground what we're doing. And the question is, like, how defensible are those assumptions? How reasonable are those heuristics in practice, given what we actually want to achieve? And what I would say is that those are a lot of technical work on this topic. I think what's sort of missing is the realization that because these are choices, these are also things that should be disclosed along with the explanation. So when I receive an explanation, I should be told the method by which that explanation was actually generated, right? Was it a counterfactual explanation? Was it a counterfactual explanation using some heuristic about trying to figure out which features are most easy to change? What were the assumptions that were made as part of that explanation method? In order to even understand where this explanation comes from, or to be able to figure out what to do with it, I think it's important that these things also be disclosed along with it. Okay, and so I think you might end up feeling that, well, what do we do here? There's not really some silver bullet, and I think that is in fact the case. It's pretty obvious that we're sort of navigating between two difficult poles. One is that full disclosure of the model, especially for a complex model, will overwhelm consumers. And partial disclosure may mislead them. So full disclosure means that, like even if the law required that some of these models be completely open to the public, it can be very challenging to interpret them. And it's very likely that consumers would actually rely on similar methods, similar explanation methods to try to even probe what these models are doing, and sort of ends up kind of back in the same place anyway. And partial disclosure, I was saying, you might end up not knowing that there are certain things you should have objected to because they weren't even disclosed, right? You weren't told that this other feature mattered because the choice of what to highlight only focused on these other features. And consumers might resign themselves to failure, not realizing actually that there were other paths to success that simply weren't shown to them. So this is a sort of like, these are the two undesirable poles in which I think we're trying to operate. And so finally, I think what this suggests is that, and this maybe is the kind of interesting irony here, is that respecting consumers' autonomy in this context might mean that we have to make some choices on their behalf, right? So if we just defer everything to consumers, it will be very difficult for them to know what to do. But if we give full power to the lender, for example, they might actually engage in self-dealing, right? They might actually give explanations that advance their own interests. And so the question is, what is the alternative here? How do we actually try to navigate this tension I mentioned? And there are other situations like this, right? So even in lending, we have things like fiduciary responsibilities, or in kind of finance, where there are actors who are much more expert than consumers. Consumers are not in a position to know how to make good decisions for themselves. And so we place some degree of fiduciary responsibilities on these actors. And so you might ask, do we want there to sort of be fiduciary obligations on the part of the of the actors who are explaining these decisions, that they're trying their best to actually give explanations that they think will advance consumers' interests? And under those conditions, maybe actually even these partial disclosures can be autonomy enhancing. My final slide is that I think there's just a lot more work that needs to be done in this area. I've been surprised at like the utter lack of empirical research. As I had mentioned, adverse action notices have been around for decades, and as far as I know, there's been zero empirical research investigating their efficacy. No one has really done work looking at how consumers make sense of these things. And we're sort of barreling forward as if these things actually work well in practice. And so there's just a desperate need for more empirical work. Here in the United States, there's even like an opportunity to do this kind of work. The Consumer Financial Protection Bureau has a trial disclosure sandbox, which is a kind of safe harbor to explore different methods that might at the moment not be fully endorsed by the law, but might be a way to experiment to see what works well. And so this is just sort of my plea for more people to do work actually looking at how these things function in practice. Okay, we'll stop there. I apologize if I've gone on too long.
Wow, thank you for this great talk. Raises all kinds of questions. And I look forward to having an interesting discussion in the time we have left. So again, raise your hand if you have a question or a comment. If you would prefer not to be recorded, feel free to put your comment or question in the chat, and we'll monitor that and take it from there. So let's open this up to discussion. Ned.
Yeah, I just wanted to ask Solon, when you were proposing that it might, respecting consumers' autonomy may require making choices on their behalf, is that the decision about which type of explanation to provide? Yeah, okay, I just wanted to clarify that was the decision. Okay, interesting. Sorry, I'm just still thinking about that.
That's right, then. Yeah, and this is actually a direction that Manish and I are also further exploring. And one thing I didn't get into here is that, interestingly, in the United States, these explanations are required not only when you've been rejected for a loan, but even if you've applied for example, a mortgage, and you've requested certain terms, and then the bank has offered a loan, but on less favorable terms. And what this means in practice is this highlights that it's almost never in these contexts a yes/no decision, like lend, don't lend. It's often lend on these terms or on these other terms, right? Like, what is the interest rate? What is the down payment? What is the repayment schedule, etc. And the reason this is relevant to this question is that you could give explanations that end up sort of maximizing the utility of the bank, right? Like the most desirable terms for the bank, not the terms that like the consumer themselves would specifically want. And so it's easy to imagine explanations being a way of engaging in self-dealing, right? Like, oh, just take these actions and we'll give you a loan. What they could be doing is directing someone to terms which are especially like unfavorable to the consumer, even though there could have been other actions the consumer could have taken that would have been just as easy to accomplish, but would have allowed them to gain access to much more favorable terms, right? So this is something we're sort of thinking about, that these choices about what kind of explanation they give really can reflect the interest of the decision maker, much less so the subject of the decision.
Okay, so we have Loki and then Liz.
So I've seen this sort of thing in practice here in Australia, and when I was in practice as a lawyer, I had to explain to clients many times why the court has made a decision that it has, or why they're not getting their money back, and the law, as I understand it, and from what you explained there, they've listed off a set of things to do, but they haven't actually, have they set out in the law your disclosure to the customer needs to achieve these things? Yeah, that's what I thought. There's a lot of that sort of laws that set out what they think are going to be appropriate proxies for the thing they actually want you to do. And so what you get is compliance, but the compliance is effectively malicious because you're on your just a list. What does time have to do with? And what we've seen with a lot of AI stuff, when you throw a lot of data in, they find correlations between things that no human would consider to be relevant to the decision. But they've sifted through all of the data and found that everybody who got a tenure was white, had gone to this other school, and happens to drive this kind of car and wears this T-shirt on the weekends. Or pictures. The pictures with sheep in them are the ones with green grass. So green grass means sheep. And this sort of stuff pops up all over the place with.
Yeah, I totally agree with you, Loki. And this is sort of why I was saying too, I think like it's been shocking to see that there's so little empirical work because yeah, the requirements are sort of like what information needs to be disclosed. It's not have you fulfilled the goal that we have in mind for introducing these requirements. And it's clear that like the agency itself even realizes that there's just like a lot of flexibility here that could just be abused to allow you to comply without actually really helping people in any meaningful way. So I completely agree.
Do you think that part of the reason that there hasn't been a lot of empirical work here is that the people who are benefiting from this don't really see a need to do the empirical work to explain or to investigate what might not be going well.
Yeah, that's a good question. I think what's interesting is that like banks certainly, or lenders certainly should be able to assess the quality of things, because you could probably do experiments, right? You can see consumers who are essentially equivalent. If we give them this explanation and we give that other one that explanation, like, does it actually even matter? Like, if we track their financial history, you should in theory be able to do some kind of experiments, and they're dealing with large populations that they have the power to actually figure this out. I think what's been unnerving is that the Consumer Financial Protection Bureau, when it takes enforcement actions, can actually even see the adverse action notices that have been issued. So they in theory have visibility into a huge number of such notices, but I don't believe the Bureau has ever done like its own analysis of what those things say, of whether they actually translate into any meaningful change in consumer behavior. So if there is one actor who's especially well positioned, who's not financially conflicted, it's the Bureau, and I don't think they've yet done this work.
Okay, so we're going to go to Liz, then Johnny, and then we have a question in the chat. So Liz.
I'm actually asking the question in the chat because
Okay.
this is from Joseph. Any thoughts on how counterfactual explanations might apply differently to correcting incorrect information versus identifying opportunities for change? Or do we just want disclosure of what information is on file?
Yeah, this is a great question too, and thanks for reading it, Liz. So I think counterfactual explanation. Actually, I mean, I would say that both of these methods are not necessarily, which are, I think, these are not. This is not exhaustive, just to clarify, but like the kind of column on the left here is what, again, like is suggested by the regulation, and the column on the right is sort of what is the dominant view in, I think, the computer science literature. Neither of these would really necessarily help you uncover that there was like a error either in the input or even in the model's reasoning, right? There's like, it's just sort of helping you understand that like, these are the features which in some sense contribute to this outcome. Nevertheless, I think both of these methods are often held up as a way of discovering that, but like, it's entirely possible that both these explanations will just tell you that, features that are correct in the sense of like their input value is correct were the ones that were decisive, and then you would have no way of knowing that actually there was some piece of information that was incorrect that still played a part but wasn't perceived as being decisive using these methods. So I think these are not reliable methods for uncovering errors. And in fact, just having disclosure of the input information is actually what the Fair Credit Reporting Act does here in the United States. So I don't know what it's like in other countries, but consumers have the right to access the information that's held in these credit reports, and they can do so on an annual basis. In the United States, there's 3 primary bureaus that collect this information, and it's not the score, like it's not your credit score, it's literally the inputs to your score. So, any past defaults, how much debt you're maintaining, etc. And that's often, I think, how people are expected to discover that there's error in the input. The final thing I'll say though is that like, if what you care about is that like the reasoning the model follows to determine who is creditworthy is just faulty, right? It just does a bad job. There's nothing about any of these methods that I think actually seem particularly helpful.
Okay, thanks. So I still see 2 hands up. I think we'll go to Johnny next.
Okay, great, thank you. So I have a question that's for clarification, and then another one that is not. So the first one is, when you're talking about empirical work, is that talking about it from a psychological sense? So sort of how, so about how people are processing and responding to these explanations. And secondly, do additional separate or modified methods need to be put in place for vulnerable groups who might not be able to understand in the same way as someone who's not in those groups?
Those are both great questions. I think I haven't contemplated the full range of empirical work that could probably be done, but certainly some of it could be psychological in the sense of like trying to probe how consumers process this information and the kinds of plans they might put in place given these explanations. The things I was thinking about was actually maybe even more straightforward, where we don't necessarily try to understand the psychology of consumers, but just investigate whether receiving these things actually even changes consumer behavior. So if it does nothing, right? Like if they receive this and nothing changes, then that's evidence that somehow this is not really serving the function we might imagine. I should say that like in talking to people in industry, I think a lot of them see it as sort of like providing a rationale that helps people accept their fate, right? It's like, this is not an arbitrary decision. You should accept that like we've done something reasonable here, and unfortunately it hasn't come out in your favor. It's not perceived as like, let's give them advice to in fact get to a better outcome, despite the fact that that's what regulators might hope. And so in practice, I think it feels very much more like, don't challenge us. Like we've done a decent enough job here thinking about this, and this is not arbitrary. But again, like I think many of us, including the regulators, want this to be more than that. And if it turns out that like the evidence doesn't suggest consumers do anything differently when they receive these explanations, then I think that's real clear evidence that we have to rethink the method. The question about like whether there are particular populations that might require special attention, I think it's very much in keeping with like longstanding concerns around there's being vulnerable populations in financial markets in general, right? So certainly, yes, like I think like there are going to be people who are especially vulnerable to predation and being given kind of unfavorable loan terms and what have you. And I think even explanations could play a part in that, as I was saying, right? Imagine you're basically given explanations that are steering people to like especially risky terms, right? Like we can help you get just across the boundary. So you can get the loan, but the prospects of you defaulting are pretty high, right? Or you can get the loan, but the interest rate is pretty onerous. So, I think there's a lot to question there too. And that's, I think, also what we might, again, want to think about like sort of fiduciary responsibilities. Like, given that these consumers are not in a position to know how to make judgments for themselves, is there a burden on the decision maker who's explained the decision to try to actually look after their interests?
Okay, so Liz, do we have another minute or two for a discussion?
We can do one last question, I think, yeah, if that's all right.
Okay. All right, so I have one, but Lockie had his hand up first, so maybe, can we do two?
Yeah, that's fine.
All right, Lucky, go ahead, and then I'll throw mine in.
This is the thought that has occurred to me in all of this. Given that most of what's happening here are the people who have the expert knowledge, looking at what little they can tell or what it is they expect these things to achieve. Has anyone actually talked to the people who are trying to understand these things and asking or looking at what do they actually need to know and in what form? Because you go to that group and they will tell you something completely different from what the finance person will tell, because the finance person knows how financing works, whereas the person going for the loan needs to understand what is it that they actually need to be doing to be a person who can get a loan. And if they don't get a loan, how does this help them understand, can you just provide them with the information they need to know? Would probably be a lot simpler than having, but you see this kind of detailed law that just doesn't achieve any of the ends. It becomes a compliance game rather than, but I'm just wondering if you actually know of any research where anyone's gone and talked to potential lenders, potential mortgagees, to go, so what information would you like to have or need to have up front, or if you've not succeeded, that would make this process make more sense? Because the Australian regulators are dealing with this as well, and I'm not sure they're doing any better.
Yeah, so this is a great question, Loki. I think like for the past couple of years, there's been a lot more empirical research on assessing the utility of explanations. And so I just refer you back to this paper by my colleagues at Microsoft Research, which cites a bunch of this work. But to my knowledge, though there's been lots of work done, much of it is in lab studies, right? So it's like you recruit some people, you see how they actually respond to things in the lab. Sometimes it's in actual applied domains, but I don't think I've come across any work that's done this with applicants for loans. So I am not aware of like a study that's specifically trying to do it. The closest thing I can think about is I have a colleague back at Cornell named Malta Ziewitz, and he, with some colleagues, have been actually talking to people in the Ithaca area. This is the town where Cornell is located.
Yep.
Trying to understand how people who have really bad credit histories attempt to repair their credit history.
Yep.
And so, and that's like very hands-on, like ethnographic work. So they're really trying to understand like what consumers, like the kind of, what's the word I'm trying to think of? The kind of like theories they have about how the credit system works, why they take certain actions. They often rely on these like experts who give them advice about how to navigate the system, or even these like companies that you pay certain money to that will help you in this process. And so that's the closest I've seen, but like that's not narrowly focused on explanations. That's sort of more generally about how consumers sort of understand this process. And that's the only thing I know about. I can kind of put something in the chat afterwards.
Because I was thinking that might be something that you might find some people who might do that part of that research that dovetailing with what you're doing.
So one final quick question, comment from me, and I know we're over time here. It strikes me that there are three players here. There's the machine or algorithm, there's the human being working with the machine, and then there's the consumer. There may be situations where the human being working with the machine is better able to interpret and explain a decision to the consumer, maybe because they've learned something about the consumer. On the other hand, it may be safer because human beings make mistakes and they're prejudiced and so on, that the machine might be trained to make explanations itself and so on. Are there any guidelines as to situations in which machines should be allowed to do the explanations without human interpretation?
That's a really good question. So, and here again, the US, like the law is quite specific. It sort of says like, it recognizes that some of these like lending decisions are the joint result of using like a statistical model and then a human being involved in some part of the process. And what the law says is that like whichever part of the process determined whether someone was like not a good candidate for credit needs to be part of the explanation. So like if, for example, the statistical model says like, yeah, they're great, but then the human has some additional knowledge about the applicant that somehow is a mark against them, then even if the model said like everything's great, the explanation still has to point out that the human actually overruled with this particular piece of information. So at least like the law at a very high level is at least like cognizant of this. It's sort of saying like whatever part of the process is decisive, that needs to be held out. But I think it's like a slightly, it's a slightly weird question because it's a slightly weird scenario because you can imagine the following thing, which is like, the model thinks like the best this explanation to give is A, right? Like here are the features that you should change. But actually the human knows a lot more about the applicant. It knows, for example, that like they're about to get a promotion, or it knows like they're about to have a kid or whatever, like a bunch of details that are just not going to be available to the model. And so the model might think the best explanation to give is A, but the human has all this other information that actually points out that actually the better explanation is to give is B, right? And I don't know what the law thinks about that, right? It's like, that seems like actually exactly what I would want to happen, right? Like we can use auxiliary information to help tailor the explanation to serve the interests of the consumers. But it's not obvious to me like how how regulators would think about that. So
Well, we could carry on this discussion for quite a long time. I know it's really late in some parts of the listening and participating audience. So let me simply say, Solon, thank you for the stimulating talk, and thank you everyone for the participating in the discussion. And now I'll hand it back over to Liz for closing remarks.
My closing remarks will be very short today. All I really want to do, first of all, is say thank you so much to everyone who participated today, who spoke, who chaired everything today, Fred. I really, really appreciate it. It's been a really wonderful session today. And tomorrow, I will just share that we are going to have a case study exploring social responsibility of digital agriculture, which will be quite interesting. We're going to have a contribution panel with Nick Matei from Tulane, Kathy Reed, who is definitely not just tech support from the ANU School of Cybernetics, Meminat Ibrahim is also from the ANU School of Cybernetics. And we'll have a keynote talk from David Rios Insua from ICMAT. So thank you so much. I hope you all have a wonderful rest of your day, afternoon, or evening, wherever you are.